review, our office looked at about 160 cases of people who were incarcerated where they felt that DNA could prove innocence, because of course, lots of cases there is no DNA. In other cases, there may be some DNA, but it wouldn't necessarily be relevant to prove innocence. But looking at those cases, there were 3 cases where she would have done DNA testing. In 2 of those cases, the DNA had already been lost or destroyed. But in Mr. Sutherland's case, they were able to find the victim's underwear. That was tested and resulted in the exoneration of Mr. Sutherland. What was very interesting and also kind of common in these DNA exonerations is they were able to use that DNA profile then to upload it to a database of felony offenders, and they did find who the true perpetrator was, who's on the next slide. It was a guy by the name of O.C. Pankey. And it's true in about just under 50% of the DNA cases, they are able to take that profile that did not belong to the convicted offender, put it into the database of where they capture felony offenders' DNA and find who the true perpetrator was. Unfortunately, in many of those cases, that person had actually gone on to commit additional crimes, serious crimes, including other rapes and murders. I wanted to talk about a national case as well, because I think it represents a lot of what is happening in these cases and how we can help inform the courts and law enforcement about a better way to handle these photo array and lineup procedures. This is the case of Ronald Cotton. As I'm talking about it, some of you may recognize some of the facts because Ronald Cotton, along with the victim in the case, Jennifer Thompson, have done a lot of speaking. They wrote a book and they were on 60 Minutes, where they actually had 2 segments, resulting in 30 minutes worth of 60 Minutes time, which was unusual. But in this case, Jennifer Thompson was a young woman. She was asleep in her home and she woke up in the middle of the night and there was an intruder. The intruder proceeded to sexually assault her. And Jennifer was very brave. Throughout the sexual assault, she decided that she was going to look at the perpetrator, focus on him so that she would be able to accurately describe him to the police so they could catch him and he wouldn't do this to anyone else. When the sexual assault was done, she asked the perpetrator if she could get up and go into the kitchen and get a glass of water. He allowed her to do that and followed her into the kitchen, where even as they walked, she tried to judge his height relative to hers. When they got to the kitchen, she was able to escape and run to a neighbor's house. Law enforcement were called, and she helped law enforcement put together a composite sketch, which is in the next slide. And this composite sketch then appeared in the media, and a friend of someone, an acquaintance of Ronald Cotton, called into law enforcement and said, "Hey, I think this guy is Ronald Cotton. It looks a whole lot like him." So law enforcement put Ronald Cotton's photo into a 6-person photo array and went to show it to Jennifer. And during that photo array, Jennifer picked out Ronald Cotton as a possibility. She was not 100% sure, but she was pretty certain. And she said to the law enforcement officer, "I think it's this guy." And the law enforcement officer said, "Good job, that's who we thought it was." With that affirmation, she felt her credibility go up. She felt like she had done a good job and that she got the correct suspect. And from that day forward, when she thought about the attack, it was Ronald Cotton's picture, or Ronald Cotton's face, that was in her memory. Essentially, as I'm sure you know, the way the story is going to go, he is ultimately exonerated. But that false memory was created by law enforcement, probably unintentionally, just by giving her that positive feedback. Ronald Cotton was convicted, went to prison. While he was in prison, he heard that another man by the name of Bobby Poole was bragging about this sexual assault and sort of laughing that Cotton had been convicted of it. For reasons having nothing to do with innocence, his case was overturned on direct appeal and he was retried. Ronald Cotton was retried. Before the retrial, he went to his attorney and said, "Hey, there's this other guy in prison with me. His name's Bobby Poole. He's the one who actually did it." Law enforcement or the prosecutor actually had Jennifer look at Bobby Poole, and she said, "No, that's not the guy. It's Ronald Cotton. I'm sure it's Ronald Cotton." Ronald Cotton was convicted again, sent back to prison, and it wasn't until a number of years later that DNA testing was done. It exonerated Ronald Cotton, but in fact, again, they were able to match it through the database to Bobby Poole. And I've got a couple of pictures of them that I can show you. That's Ronald Cotton, and then the next picture will be Bobby Poole. And then I have a picture of the 2 of them together. I don't know how this picture was taken. It was obviously taken in prison. I don't know why it was taken side by side like this. But one of the things, so Jennifer Thompson obviously learned that she picked the wrong man, that it was Bobby Poole. She was devastated to learn that she had caused Ronald Cotton to spend this time in prison. And one of the things that was very puzzling to her, you can see they really don't look alike, but the height difference. She thought that she had a very good handle on the height of Ronald Cotton. Of course, you can't tell that from a photo array, but she was very surprised that even in court she didn't pick up on that. A couple of years after his release, the story has kind of a nice ending. A couple of years after his release, Jennifer asked Ronald if he would be willing to meet with her so that she could apologize to him. They did meet. He apologized to her, and they became very good friends. And as I said, they wrote a book together. They did a lot of speaking together, and she has started her own nonprofit called Healing Justice to help the victims in these cases. So, stepping away from some of the stories, and I do want to talk about the law involved in mistaken eyewitness identification. The law of the land that the Supreme Court announced in Manson v. Braithwaite is still what stands. That is the constitutional standard for contesting an eyewitness identification procedure. And what the court says is the first thing that they would look at is whether the line of procedure used by law enforcement was unnecessarily suggestive. If the defense could show that the line of procedure was unnecessarily suggestive because of what law enforcement did, then the state would have to prove, or the prosecution would have to prove, that given the totality of the circumstances, it was still reliable. And those totality of the circumstances really went to what the victim or witness saw. Did they have a good opportunity to view? Were they paying good attention? What was their degree of attention? Was the description similar to the person who was then, arrested and the defendant? What was their certainty? How certain were they of their identification? Although we've since found that that's certainly not a stand-in for accuracy or reliability. But that is what stands now in our country as we use the Manson v. Braithwaite test. What happened, though, just a few years ago, well, now probably 7 years ago, was the New Jersey versus Henderson decision. It's not controlling, but many courts are now referring to it when assessing their standards for allowing these eyewitness identifications to be introduced in court. And basically, well, what happened in New Jersey v. Henderson is there was a party or a small gathering on New Year's Eve. Two men broke into the party, and eventually one of them shot one of the other attendees at this gathering or party. One of the witnesses was brought in by law enforcement to go through a lineup with law enforcement. He eventually got down to sort of being between two of the potential people in the photo array, but was really uncertain. And then law enforcement started to pressure him to pick Henderson. And we know this because he testified to this at a later hearing, that he really felt that law enforcement were not going to leave him alone until he made a specific selection. The defense sought out suppression of this procedure because in New Jersey, the Attorney General had already promulgated some regulations about how law enforcement was supposed to do these lineup procedures, which law enforcement in this case did not follow. So what the Supreme Court in New Jersey did was they sent this to another judge who they appointed as a special master to review all of the literature and studies that had been done in the area of mistaken eyewitness identification. Because in addition to Innocence Projects being very interested in this, social scientists had been for many years and were doing a lot of different studies at various colleges, working with manipulating different factors of eyewitness identification and determining the best ways that it should be done. So the court looked at this in Henderson and sort of followed the Manson v. Braithwaite framework in looking at systemic variables, which were those variables controlled by law enforcement, and then estimator variables, which were those variables that had more to do with the witness and their ability to see and remember what they had seen. And what was interesting is many of the things that we rely on in Manson v. Braithwaite are still correct, but they expanded on those categories significantly to include specifically cross-racial identification, weapons focus, the acknowledgement that someone who's under stress may not be very good at making eyewitness identification, and looking at systemic variables, how law enforcement is going to conduct that lineup procedure, and making recommendations about the best way for law enforcement to do that. It turns out these same recommendations that came from Henderson were echoed by the National Academy of Sciences just a few years later. And so I want to talk about those systemic variables, the most important one being a double-blind lineup procedure, simply meaning that the law enforcement officer who conducts the lineup with the victim or witness does not know who the suspect is, to avoid any intentional or unintentional biasing. And of course, we can all think of intentional biasing, right, where law enforcement shows the victim or witness the photo array and says, I want you to take a special look at number 5. Doesn't number 5 look a lot like who you described to me, right? That would be an intentional biasing. But I believe what happened in Jennifer Thompson's case was an unintentional biasing, where the law enforcement officer responding to a victim simply wanted to reassure her that she did a good job. But look what it did to her memory. It created this false memory for her that even exposure to the true perpetrator could not correct. So we want this double-blind lineup procedure, and in fact, it was recommended, again, not just by the court in Henderson, but also by the National Academy of Sciences.
And Julie, that confidence factor is important, because at trial, when the victim is asked who committed the crime, he or she is going to name the defendant, and then the prosecutor will ask, how confident are you in that decision? Right?
Yeah, and the victim will say, I'm certain that's the man. I will never forget that face as long as I live. But it turns out that studies have been conducted that show that confidence, that certainty, doesn't necessarily equate to reliability. But think how hard it is to cross-examine that victim. The typical tool of cross-examination that can flush out someone perhaps who's lying. What do you do with a victim who absolutely believes what they're saying? You can't cross-examine that away, right? It's very difficult. So again, this idea that law enforcement might accidentally create false memory can be fixed very easily through the double-blind lineup procedure, and that's the most important of these. The other thing that law enforcement is asked to do is, next slide.
Oh, thank you.
Sorry. That law enforcement should take a certainty statement about the identification, again, without commenting on the merits. So if you've got a victim or witness who says to the law enforcement officer, well, number 3 kind of looks like the guy, but the eyes are different and the ears are different. So I think it's him, but I'm really not certain. Now that same victim or witness comes to trial and says on the witness stand, that's the face, I'll never forget that face as long as I live. Shouldn't the jury know about the earlier statement? Especially because when you think about it, the easiest thing in the world for a person to do is make the in-court identification, right? I remember when I was a kid watching Perry Mason, you would see somebody on the witness stand say, that's the man, I'll never forget it. I'm like, well, who else is the person gonna, right? It's just rife with the potential for bias. So the jurors should certainly know if they made other statements early on, closer in time to the crime, that reflected less certainty.
Well, and we don't have the circumstances now that another witness would then pop up and say, as they would for Perry Mason, no, I did it.
Yeah, right. That perfect moment that happened at the end of every hour. You're right, Perry, I did it. Yeah, no,
Right.
That's only on TV. The next slide, if we could. This is a very simple one as well for law enforcement to do. Tell the witness or the victim that the suspect may not be in the lineup and they will continue to investigate the case, right? Give the victim or witness the opportunity to say, I'm not certain. I don't see the person here, that they don't feel forced to make a decision. Again, very simple thing to do. Next slide. This seems like an obvious one, but I've got a couple of examples to show you. Obviously, law enforcement must compose the lineup so it doesn't draw undue attention to the police suspect. I always use this lineup from Texas to talk about this because the perpetrator in this case was African American. I know it's a little pixelated, but there's only one African American in that lineup. So I used to always show this because I like to make fun of Texas. Until, and don't show the slide yet, Devin. Until a reporter for the Star Tribune sent me the lineup that I'm about to show you that was composed by a Minneapolis police officer just a couple of years ago and emailed to the witness. So this lineup procedure wasn't even done in person. It was emailed to the witness who had said the perpetrator that he witnessed was a young Hispanic male. Now you can show the lineup. Look at that, right? Maybe there's 2 or 3 Hispanic guys in there, but there's at least 2 white guys. Maybe there's 2 or 3 young people in there, but there's at least 3 guys who look like they're in their 40s or 50s, really. And of course, the guy on the lower left, I think it looks like John Hamm after he's gotten arrested for a DWI. If anybody knows who he is from Mad Men. You know, that's incredible, right? Like, this is not a fairly composed lineup. If you're looking for a young Hispanic male, frankly, if you're looking for any description, right, this is just all over the board and absolutely inappropriate. Came out of Minneapolis just a few years ago. Next slide. And finally, this one I think we do very well here in Minneapolis is law enforcement must document the lineup procedure. Well, we don't actually do it electronically, sorry, but they can also do it in writing. So the good news is I can tell you that the legislature last year at the end of the 2020 session did pass a law requiring law enforcement throughout the state of Minnesota to use these best practices when conducting lineup procedures. So we are hoping that some of those problems in the early piece of the investigation go better. But what do we do in the court system? And that's what Jevin and David are here to talk about. Obviously, there are suppression hearings. We're still operating under the Manson-Braithwaite standard, though. But there's also some other suggestions that they're going to talk to you about expert witnesses and jury instructions. Sorry.
Well, let me step in on expert witnesses, because I think a lot of us had our eyes open to just the extent and the importance of expert testimony from the recently televised Chauvin trial, where experts play a huge role. But that's a remarkable case with, you know, massive resources devoted to the prosecution of the case. And it was, it isn't obvious just how practical expert witnesses are for the much more, I hate to say routine or mundane, but run-of-the-mill criminal cases. And eyewitness testimony can come up in so many circumstances. It's not just murder cases and rape cases. I mean, a purse snatching, you know, is a great example of where eyewitness testimony may be the main testimony. And there are many bases for challenging the opportunity of a victim or a stranger witness to identify someone in the fleeting moment of a purse snatching. The place that we start with for expert testimony, obviously, the rules of evidence on experts, and that rule is Rule 702, and it has a couple of key parts that seem more important in the eyewitness circumstance than many other cases involving experts. And that is, it requires the judgment that the expert testimony will assist the trier of fact to understand the evidence or determine an issue. And I think we see in some of the cases, and I'll suggest that it's not uncommon that the judge will not see the need for, or the likelihood that the testimony would be helpful. And I'll discuss a case in a moment that recognized the court's pretty broad discretion to exclude expert testimony that's the judge views is not helpful. And in fact, that has been one of the bases for excluding eyewitness evidence about the reliability of eyewitness testimony. And it can be significant. The 1980 case from Minnesota of Helter Brittle is an interesting case. It goes back, obviously, 41 years. It's written by Associate Justice Doug Amdahl. It was in his first year or two on the court before he was made chief. And it recognized clearly the discretion of the court to receive that evidence, but also the discretion of the court to exclude it, and affirmed in that case the exclusion of an expert on the reliability of expert testimony. And that's been an important case ever since. Now, before going further, I think one of the ways that litigators ought to have in mind, and I don't know, I mean, I think listening to Julie, we would obviously hear in particular how this is an issue of interest to defense lawyers or lawyers trying to obtain exonerations. But I have to think that prosecutors and defense lawyers would have occasion that they would want to make sure the jury understands the frailties of eyewitness testimony. It's not uncommon that a defendant would offer an eyewitness testimony to say that's not the person, or and I think you face an uphill battle maybe with the judge. And to me, that calls out for an offer of proof, not just I'd like to offer this testimony, but I'd like Your Honor to hear this testimony and understand this testimony so you can rule on the other side's motion to exclude it, because I think it's very important, and we submit it's very important to the resolution of this case. And I haven't seen that being done consistently in the cases I've read. But it's a great way to, and it's a lesson I've learned from reading about and trying to get cases or litigating motions in limine with judges. Often their first response to some evidentiary question may be one thing, but once in the context of it and fully understand just what the evidence would be, they would reach the opposite conclusion. And I think that would be a worthy strategy for litigators in the eyewitness testimony area.
David, I have a quick question, and maybe this is a question for Julie actually, but are you aware of whether experts for the prosecution are more likely to be allowed by judges as opposed to defense experts, or whether the prosecution might have more resources to have an expert testify at trial?
Well, I think there's, the resource issue, I think, is fairly clear cut. I mean, I'm pretty sure the public defender's offices don't feel like they have the resources of the state crime lab and the, all of the resources that the prosecution has. As to the judicial attitude, I don't have any information on that, or don't know that there's one side has an advantage in that generally. I'm sure there's an opinion on that though.
There is a study done, and I'd have to find it, but I remember reading it and being not surprised that in criminal cases, the judge is far more likely to allow the prosecution's expert than the defense expert. Whereas when looking at civil cases, it cuts much more 50.
And yeah, I'm not familiar with that. I remember from my days clerking in the district court that more than one judge telling me that criminal cases were easy to try because you just rule against the prosecution on everything, and then the judgment will be affirmed. So that may not be the way it works. I think it probably isn't exactly the way it works, but I had heard that as a maybe semi-facetious description of the process. But in the next slide, you can see what I consider to be very interesting. This is what the Supreme Court offered as reasons, as alternatives to expert testimony. Prosecutorial discretion not to prosecute. I'm sure that that's a possibility, and that certainly happens. How many times that happens because of not trusting the eyewitness testimony or thinking the eyewitness testimony may be wrong, I'm just not sure in the reality of that, how important that is. The discretion to suppress the eyewitness testimony. I'm not sure what the basis for suppression is going to be unless the court wants to say it's so clear cut. And this would be true for lineups or show-ups that are unfair, that exclusion is what you're looking for. In reality, most of what I think we've been focusing on here is giving ammunition or giving a tool to the jury to make a fair weighing of the evidence, and assuming that the eyewitness will testify. How much weight should that testimony get? And Julie, you might be able to elaborate on this, but that's fundamentally the problem, is that jurors or fact finders do not understand intuitively the frailties of eyewitness testimony, and they really need some information about that. Not the answer to the question in this case, but here are some things that you ought to weigh when you weigh the evidence. We don't need to do that generally for witnesses, percipient witnesses generally, about, how good is someone at judging the speed of a vehicle, or how good is someone about relating whether the light was red or green, or those sorts of things. But for eyewitness, they don't understand that people are frequently wrong.
That is true. And there's actually an article called Beyond the Ken, K-E-N, that talks about whether this expert testimony will be helpful or not to jurors. And it actually, they went through and they did a study with jurors and also judges and attorneys to see which different factors, so weapons focus, cross-racial identification, stress, how much each group knew about how that could affect an identification. And it turns out judges and lawyers understand this quite well, but we definitely overestimate what jurors understand. And when looking at the jurors and the lay people, they did not understand the effects of these different sort of estimator variables on the reliability of the identification.
Interestingly, the court in 1980 identified the fourth item, the availability of a proper instruction on factors to evaluate eyewitness identification testimony. But as we'll see, and we've seen many cases where the courts have declined to do that. And one of the things that the three of us put together is an article that has an instruction that at least would be of some value in crafting an instruction for a particular case that might meet that. I mean, and I don't think there's any question that in some cases, a proper or helpful jury instruction probably is a good solution, because experts are not routinely available. And I'm not sure we want, even if, the sky was the limit in terms of budgets, I'm not sure that every criminal case ought to have eyewitness testimony expert as well as DNA experts for speeding cases and, things that don't involve DNA even. The burden of proving beyond a reasonable doubt, yes, that's there, but does it actually protect against the risks here? The requirement of unanimity, and the appellate court's ability to grant relief. But it seems far-fetched if there's essentially unopposed evidence from an eyewitness is the key witness in the case. The appellate court has a hard time really dealing with that. So the next case, and really what I think is, is most recent and maybe most helpful case, is also one of the more unusual cases in the annals of appellate jurisprudence in Minnesota. That's State v. Ferguson. First-degree murder conviction, appeal raised numerous issues, and the court didn't reach the issue of excluding the witness for of the eyewitness identification expert. But the opinion's author was Justice Paul Anderson, speaking for a unanimous court, except for one concurrence. The lengthy concurrence of Justice Paul Anderson, concurring in his own opinion. But it discussed several issues, including the exclusion of eyewitness identification. And on that point, I think it's useful, and really we ought to be cognizant of it, because it talked about a less than ideal lineup, and it science, particularly from the New Jersey case that Julie cited earlier, there really is a lot more known about the frailties of that evidence in the last 20 years. So that's really where it goes. I think that concurrence really may have some value at some point when the court decides to take it up. We have tried on more than one occasion to encourage the court to take an eyewitness identification case for the Innocence Project. And so far they've, as is often true when you tell the court, this is an opportunity for you to decide something, they may not view it as the same opportunity that we do in promoting that opportunity. But that's really it. And the jury instructions, and Jevin will talk about that, I view those as really an alternative to an expert witness. And you remember in the New Jersey case, the judge appointed a special master and 7 experts, court-appointed experts. Great idea. We can't do that in every case. It's got to be an unusual case. Jevin can talk about how we maybe can find an adequate substitute with jury instructions.
Yeah, so before I jump into jury instructions, I just want to read a few comments we've received in the chats here. So first, going back to the Ronald Cotton Bobby Poole photograph that Julie mentioned, one participant says that in the book, The Invisible Gorilla, it was stated that Ronald Cotton tricked Bobby Poole into taking that picture. And that book has other stories about that case and other interesting similar stories. And then on the Minneapolis lineup that was emailed to the victim, one participant says that their colleague had this case and that she had that lineup hanging on her office door for quite some time. So I guess that there is a level of notoriety that lineup picture has garnered. Another participant says that she took an evidence class in undergrad taught by a former police officer, and he said to make sure the lineup photos don't look too similar, so that you don't confuse the witness. Well, that may be true, but you lose the purpose, which is to make sure that you're selecting the correct person. And then the last comment is that the judiciary has funds for indigent defendants to get funding for experts. And I think that's true to an extent. The difficulty is, as we're going to talk about in a couple cases in the next segment, is that it's just, and as David just mentioned, it's difficult for the defendant to be allowed to present an expert, even if they have one selected, and even if they have the funds available to have that expert to testify in the case. So jury instructions are potentially a way to provide similar information to the jury that the expert would testify about, but in a more cost-effective way, rather than having an expert potentially fly to testify in Minneapolis and be paid to do so. The jury instruction can just be read by the judge with language that's been agreed to by the parties beforehand. So that can be a much more cost-effective way than the expert testimony would be. And then Julie talked about police practices and the importance of having proper lineups and other safeguards in place. The difficulty with that, of course, is that the judiciary has only limited ways to uh, um, implement and review those lineups using the Manson v. Braithwaite standard that Julie discussed. That can be a very difficult thing to overturn when you have a witness saying, "I'm 100% confident that this is the person." So jury instructions can step in to provide information to the jurors that say, well, the witness has given the statement about who they think it is. Here are some other factors that you should consider when you're making your decision about whether that person is correct. One disadvantage potentially of jury instructions is that they can tend to be highly detailed, which could lose jurors' attention and become ineffective. So that's been one criticism of the New Jersey jury instructions that were created in Henderson, that they are rather lengthy. And if a court were to read the entire instruction, it would take probably 10 to 15 minutes. So it's unclear the extent to which such a long jury instruction would be helpful. Obviously, there's ways to bridge that gap and to only provide instructions that are necessary for the specific case at hand.
I think that should be true in any case. A jury instruction ought to, discuss cross-racial as an option, as a paragraph, but if it's not involved in the case, there'd be no reason to give that instruction. And
Right, exactly. So the jury instruction that is used in Minnesota and in many states, again, is premised on the Braithwaite case, which, as you'll remember from Julie's segment, is not a jury instruction case. So in that case, the issue was whether the witness identification should be excluded for failure to put in place safeguards to ensure that the identification was proper. So in Braithwaite, the court determined or concluded that a suggested identification procedure is inadmissible unless it's reliable under the totality of the circumstances. In that case, identified at least 5 factors for the court to think about as it made that determination: the opportunity to view the perpetrator, the witness's degree of attention, the accuracy of the witness's description, witness's degree of certainty, and the time elapsed between the crime and the identification. So a couple issues here is, number one, it's not always clear which way these factors cut. So if you're telling a juror, what was the witness's degree of attention, and consider that, it's not always clear, well, if they were paying more attention, are they going to be having a better identification, or if they're more aware of the surrounding circumstances. So these aren't inherently helpful factors. The other problem is that, as we'll talk about in a minute, there's many other factors that are important to consider when determining the efficacy of a witness identification that are not discussed in Braithwaite at all. So as I mentioned, Minnesota uses Braithwaite as the foundation for its model criminal jury instruction. And here is the pertinent part of that instruction. You should consider such factors as the opportunity of the witness to see the person, the length of time, the light conditions in the distance, the stress the witness was under, the lapse of time between the alleged offense and the identification. And so we're asking jurors in this instruction to consider some of the Braithwaite factors, but not others. And then also, it doesn't explain other factors that may affect reliability. So for example, the factor talks about the stress the witness was under at the time. Well, the stress aid identification? Does it make your ability to recall clearer, or does it hinder it? And the science since that time has shown that it actually hinders identification. When you're under stress, you're less able to make an accurate identification. And then the other problem is that the jury instruction ignores many factors that aren't mentioned in Braithwaite that have become better known to impact a witness's ability to identify a alleged perpetrator. And some of those include a weapons focus. If the perpetrator has a weapon, the witness is more likely to be focusing on the weapon and less likely to be focusing on the perpetrator's face. Another one is cross-racial effect. Differences in race or ethnicity can affect the reliability of an identification. Intoxication. If the witness is intoxicated, it can affect the ability to perceive the perpetrator's face. The complexity of the situation. Are there many people around? Are there multiple perpetrators? All of those can affect. Confidence statements, like Julie was talking about earlier. If you say that you're 100% confident, the information about the perpetrator is more likely to be firmly etched in the witness's mind, even if that information is ultimately incorrect. Exposure to extraneous information by police or by other people involved, telling the witness that the identification was correct. And then finally, the out of court identification procedures that Julie talked about before. All of these are important factors to consider, and they're not currently in the jury instruction. And again, like David was saying, not all of these are going to apply in every case. So you wouldn't need 14 different jury instructions for every matter. So these issues have come up in 3 recent cases before the Court of Appeals, and the Innocence Project has appeared as an amicus in the petition for review for all 3 of these, as David was mentioning, and Julie, David, and I were involved in all of those. Ultimately, the Supreme Court denied review of all of them. So I just want to quickly talk about these cases and why they are continuing cause for concern about the court's failure thus far to provide more guidance on this issue. So in State v. Thomas, 2017, in State v. Thomas, there was a white male was walking down a street, and he was stopped at gunpoint, told to empty his pockets. The victim described the assailant to the police as an African-American with light skin, hair in a ponytail, goatee and mustache, wearing a dark jacket and a black and red baseball cap. When the police found who they believed to be the perpetrator, he was removing his hair from a ponytail, had a reversible jacket, had a red and black baseball cap with the logo of a different Chicago team. His picture was shown to the victim, who identified him as the man with the gun. So so Mr. Thomas, who was arrested for this crime, moved to have the jury consider whether the witness and defendant's difference of race affected the accuracy of the identification, in addition to the standard jury instruction. And the court declined to provide that instruction, stating that expert testimony would instead be required. And the relevant quote from the Court of Appeals is, "The day may come when our Supreme Court wishes to endorse a jury instruction regarding cross-racial identification and reassess its decisions regarding the admissibility of expert testimony on eyewitness identification, but that is not our role." So the court is saying, essentially, we identify that this is a problem, but it's the Supreme Court's job to instruct to provide an additional jury instruction, and because they have not done so, expert testimony is the way to address this. So later that year, we had State v. Anderson, in which a victim was shown a 6-person photo lineup, was unable to identify anyone in that lineup, and then after Mr. Anderson was arrested, they noted that he looked different from the photograph that they had shown the victim. So they used a new booking photo and assembled another 6-person photo lineup. And in that one, Mr. Anderson was identified as the assailant. So Mr. Anderson sought to offer testimony of an expert on the drawbacks of eyewitness identification. The district court refused to permit the expert and refused to permit the expert to testify. The district court concluded that the expert's testimony would not be helpful because it was too general. It was based on generalities about witness identification rather than this specific case. So the district court denied the request. The Court of Appeals affirmed, essentially citing the wide discretion of the district court to determine admissibility of experts under the abuse of discretion standard. And this is a case where if the district court had allowed the expert, it's very possible the Court of Appeals would have affirmed that as well. But it just shows the wide discretion the district court has, and the Court of Appeals is unlikely to reverse those decisions. The Supreme Court ultimately denied review of this one as well. I'll come back to Davis in a moment, but I wanted to talk about the catch-22 that this creates. So the district court denies a more fulsome jury instruction because an expert is required to support the instruction, but then the defendant also is not allowed to give expert testimony, and that is reviewed on an abuse of discretion standard. So there's really no way, absent further guidance from the Supreme Court, to allow this testimony or information to reach the jury on a wide scale. You might have an expert in a remarkable case, but not in the more run-of-the-mill type cases. So as a result, the Supreme Court asked the Rules of Evidence Advisory Committee to recommend potential reforms in the area of eyewitness identification. And I served on the subcommittee that drafted that report, which made multiple recommendations in many different areas, including police practices, expert witnesses, jury instructions, and standards of review on appeal. Interestingly, in the jury instruction section of the report, there was a disagreement on the committee about how to the type of jury instruction that would best benefit the state. Some members of the committee thought that the instruction should just state the factors that are that may be applicable, such as cross-racial effect, weapons focus, the stress that the witness may have been under. Whereas other people on the committee thought that it should not only state those different factors, but also provide some information to the jury about how those factors would tilt. So, example, not only saying that stress can have an effect on a witness's perception, but that stress will make it more difficult for the witness to properly identify the perpetrator. So at this point, neither the Supreme Court nor the District Court Judges Association, who creates the jury instruction guide, has adopted specific recommendations from that report. But the report is widely available on the court website. It's also a link to the report is in our article from January 2020. So I would encourage you to take a look at that. There are a lot of different ideas in there about potential ways to implement new factors that would assist with eyewitness identification and making sure that they are as accurate as possible. So I'll just briefly go back now to State v. Davis. So this case was after the eyewitness, after the Rules of Evidence Committee submitted its report. And if you wanted a good case for the Supreme Court to take to I guess, as David was saying, this case presented a good opportunity for the court to provide some additional guidance in this area. It was, again, defense requesting additional language to the jury instruction on police procedures, cross-racial identification, weapons focus. The district court denied the instruction, and similar to in the Thomas case, the Court of Appeals basically said, we don't disagree. We are aware that there's new scientific information that discusses the frailties of eyewitness identification, but ultimately it's the Supreme Court's role to extend or change existing law. The Supreme Court unfortunately denied review of that case as well. So at the moment, we're still in a position where we're hoping that additional guidance will be forthcoming in the future. And to my knowledge, Julie, there hasn't been a case since Davis that reached the PFR stage that discussed this issue. Okay. Right, and this is just talking a little bit more about the Rules of Evidence Advisory Committee report. The committee agreed that the jury instruction should be updated and modernized, but there was no consensus on the details of how that instruction should be changed. So finally, I'll just mention the article that Julie, David, and I wrote back in January of 2020, which discusses a lot of these issues in a little bit more detail, proposes an example jury instruction that I believe was written by a Ramsey County public defender and was sought to be included in the jury instructions in a case that she was working on. We thought that, we don't want to call it a model instruction, but it is an example that provides some good language, helpful language, and also provides 14 or 15 different factors that could be applicable and that the court could use to provide additional information about eyewitness identification. So I think we have about 1 minute left if anybody has any questions. Otherwise, David, Julie, and I would obviously be happy to discuss in further length or answer questions over email at a later time.
Thank you all.
Thank you.
Thank you.
Looks like you're getting lots of positive feedback, but
Yeah,
your
I always like
questions.
to stay for that.
Yeah.
Yeah.
Thank you. That was really wonderful. I enjoyed it a lot. Very clear. And what I will do, I unfortunately didn't start the recording right away, so we missed like 2 minutes. I apologize for that. Mostly me is what we missed, which is good. But I will post the recording on our website, and I always email everyone that registered when that is done. So, and I can include the 3 of you in that email.
Sounds great.
Okay. Thank you.
Thank you.
Thank you. Bye, guys.
Bye.